Good afternoon. Welcome to today's webinar, Expert Report Writing Mistakes, How to Avoid Them and Write Bulletproof Reports. One of the distinguishing features of great experts is the ability to write reports that effectively convey their opinions and methods. Simply put, great expert witnesses write great reports. In this webinar, attorneys Craig Heidemann and Nathan Duncan will discuss 10 mistakes to avoid in order to make your reports stand out. Specifically, the presenters will discuss report structure and length, necessary content, the requirements of Rule 26 of the Federal Rules of Civil Procedure, the use of technical terminology and jargon, Daubert challenges, writing for a specific audience, the use of multimedia in reports, and other helpful topics. The presenters for today's program are Craig Heidemann and Nathan Duncan. Craig is a shareholder at Douglas Haun Heidemann, PC. Mr. Heidemann's practice is limited to serious personal injury claims, wrongful death, class actions, civil rights, pharmaceutical products liability, and felony and misdemeanor criminal defense. Throughout his practice, Mr. Heidemann has recovered significant dollar settlements and judgments for his clients. Nathan Duncan is an associate at Douglas Haun Heidemann, PC. Mr. Duncan attended law school at the University of Missouri-Columbia, where he earned his JD degree in 2007. Nathan's a member of the 30th Judicial Circuit Bar Association and the Missouri Bar. He is also admitted to practice before the U.S. District Court, Western District of Missouri. Our presenters have done their best to incorporate the questions that were submitted ahead of time into the presentation. We will, however, take 2 questions and answer breaks during this program. If you have a question, please use the chat feature, which is found on the right-hand side of the screen, to submit your question, and we will answer them in the order in which they are submitted. We encourage all attendees to submit questions throughout today's program. Tomorrow morning, I'll send out an email with a link to the archived recording of this program, and we do ask that you take time to fill out the survey that will appear on your screen after today's webinar is over. I now invite you to sit back, relax, and enjoy. I'm going to turn the presentation over to our distinguished presenters, Mr. Craig Heidemann and Mr. Nathan Duncan. Craig and Nathan, the program is all yours.
Good afternoon, everybody. Greetings from Southwest Missouri, where it is a balmy 104 degrees. So hopefully it is cooler where you all are. You're in for a treat today. We've put together the top 10 report writing mistakes. We also thought about calling it How to Make the Transition from Testifying Expert to Consulting Expert in 10 Easy Steps.
Which is not good. So
kind of the converse title of this. So hopefully you won't be put in the position of losing your testifying expert position only to become a consulting expert by committing any of these report writing mistakes.
So we'll dive right in. The first one, which is important, is that you don't follow the rules in preparing your report. Now, everybody's in different jurisdictions, but one common thing are the federal rules of civil procedure, and the civil rules in your state courts are probably fairly similar to this. So we thought we'd talk in the context of Rule 26A2B, which governs our expert witness disclosures and the expert witness report.
Now, for all you salty experts that have been around for a long, long time, don't think that we're being too elementary here, because Nathan and I were talking in the practice of law, and I've been practicing for 20 years. Whenever I do motion practice and there's a rule that governs what I have to do, I still, at this stage in my career, always consult the rule every time before I do that motion practice, just to make sure that I don't miss something, because the consequences for missing requirements of the rules can be catastrophic. And I believe that everybody here would like to be excluded as an expert after a long and arduous Daubert challenge by qualified, seasoned attorneys, and after pensive thought by the judge, rather than being disqualified because you failed to follow some small rule like signing your report or having an updated list of publications.
And that really goes for not only the federal rules, but even local rules and state rules. So make sure that you are familiar with what the requirements are in your jurisdiction.
Now, of course, you've visited with your hiring attorney and you know whether the case is a state court case or a federal arbitration case or a federal civil case or even a criminal case, so that you can make sure that you're complying with the correct rules. But we'll assume for purposes of this discussion that where we have a run-of-the-mill garden variety federal civil litigation, and we'll look at Rule 26A2B.
So there's some basic things that every report that an expert prepares and is to be used in the federal case has to have.
Every time, all the time.
Every time. And the first one, and perhaps the most important, is a statement of your opinions. Any opinion that you anticipate offering during the case needs to be set forth in full in your report.
Guess what? Every report should probably have an opening section that should be called, what, Nathan?
Opinions.
Opinions. Make a laundry list of your opinions. That way you'll know what you're saying and what you're not saying. And so if somebody tries to feed you an opinion later at deposition, you can say, hey, take a look at my report. I didn't say that was my opinion. My opinions are number 1 through 3 or 1 through 10.
But keep in mind, if you want to err on the side of having, being very thorough and having maybe even a little too many, if you're going to discard opinions later, you have to do that with reasons, but it'd be better to have more. Just because if you fail to include an opinion, you will be barred from offering that opinion at trial or later. Barred. Don't want to be barred. The next thing every report has to have is you have to have the basis and reasons for those opinions.
Now, this is a subheading to your opinions. So you can have your opinions and list them out, and then you can have another section. It's kind of a subsection that goes along with those opinions that sets forth the basis and reasons for reaching them. It'll include your methodology and other, if you did tests or observations.
Right. The facts on the front, because there's going to be, in any case, there's a big truckload of facts, but only some of those may apply to your opinions.
Section 2 is information considered. So hopefully you've got an excellent relationship with your hiring attorney. He sent you the interrogatories from the other party. He sent you his client's interrogatory answers.
Deposition transcripts.
Depositions. Everything that you were given needs to be listed, and if you went out and consulted some learned treatises or you read some journal articles, you need to put that in there. If you consulted the periodic table of the elements, you might want to list that too. All information considered, and all you have to do is list it.
If you anticipate using exhibits at some point, either a deposition or a trial, you need to make sure those are identified and included with your report. Honestly, that doesn't happen a ton. I don't see those in many reports that we deal with.
But for those rock star experts that we are absolutely in love with, they send us exhibits because they know that they might like to use them at trial, and it really gives a report a lot of pizzazz. We're going to talk about that more later in the presentation, but exhibits or other multimedia items can really set you apart from the crowd.
So, aside from exhibits, you also need to make sure you include your qualifications, and we're going to give a little more detail about that, why you are qualified to render the opinions that you do. You need to include any prior expert testimony that you offered for 10 years. 4 years, I'm sorry.
It's
4 years.
And don't forget, a list of all publications authored in the previous 10 years. So if you are published, you have to have an updated list of your publications, and don't fall into the trap of one of our fancy high-dollar experts that we hired. He was asked about his publications, and he said, I don't know. I mean, I've written lots of stuff. It's just, I've written so much, I just don't keep track of it. So he excluded himself from the case because of his own laziness and not being prepared for that question.
We spent 15 minutes at his deposition listening to him and the opposing attorney fight over whether his CV was up to date with all of the things that he had written.
Anyway, don't make those mistakes. Go down on a complicated scientific issue.
If you have to go down at all.
If you have to go down at all, not on a clerical issue. So
you also have to include information about your compensation for work as an expert witness.
And hopefully you're all getting charged what you're worth, and be proud to say it.
As far as qualifications, like I mentioned, you only have to go 10 years. You don't have to keep those forever. You might include you can always attach a copy of your CV or just include those in the body of your report.
Quick note on publications. If you have a title for a publication, please include the entire title. If you have written something that you're ashamed of, I am sorry about that. But don't leave out half of the title or any of the subtitles. Go ahead and list it all, because any thorough lawyer is going to find it anyway, and then they'll attack you on trying to hide things that you've written in the past.
All right. So, yeah, update your information.
That is in red. That is important.
Yeah.
No additional charge.
That's right. And then as far as your prior testimony, it's for the 4-year period before that case on which you're writing that opinion. Now, it only counts if you have offered testimony at trial or deposition.
It is not every report that you've ever written, and a lot of experts make this mistake, and they list every case they've ever consulted on. It's only where you've been sworn in. So if you were not sworn in, don't list it. If you were sworn in, list it.
Yep. Update that information. And really, I mean, we're kind of harping on this, but here's the reason. If you have given me a list and I later find out either through your testimony or some other means that you have not been complete, you haven't told me all your publications for the last 10 years or your testimony for the last 4 years, I'm going to think you've been hiding something from me, and I'm going to kill you on that.
Little bonus, we're going to answer Harry Elson's question right now. As far as publications that we have to list, the question was, do we have to just list peer-reviewed publications or all publications? Guess what? It's all publications, because when we look at the federal rules, it says a statement of all publications authored in the previous 10 years. To be published is anything that can be copyrighted. I mean, you can copyright something that's published where it's distributed to the public or it's available for the public. So if you have published something and it's gone out to someone other than your internal company that you work for, or a very limited audience of folks, you have to list it. All publications.
Everything. All right. Moving on to our second mistake. So just to wrap up, I mean, make sure you know the rules and follow them.
The federal rules are available online. We have a link to them in our presentation, but you can just simply Google Federal Rule 26, and it will pull up a complete, up-to-date copy of Rule 26, and you'll specifically want to look again at A2B. Find Law is another great source for Rule 26.
All right, our second mistake is getting the wrong length for the report. And I had an expert, it was nice, he asked me before he wrote the report what kind of, how long the report should be and what my expectations were. So that's an important thing to note. If you don't know, ask the lawyer what his or her expectations are.
Now you all are sitting there thinking, well, I guess they really don't want it to be too long. That's really not our first example, is it?
No. We had a case, and we thought honestly he was going to be a rock star expert because he was a
treater and an expert.
The treater, the expert. He actually was the father-in-law of co-counsel. So
I thought we had everything going in our favor.
High quality. So we talked to him, and time came for him to submit his report to us for filing with the court and for submission to
a federal case.
Federal case, and this is what we got. Dr. So-and-so will testify as to the nature, extent, cause of injury to. Call me with any questions, and actually, we blocked out the signature, but that is not the doctor's signature. That's his office manager.
The doctor didn't sign it, and apparently this was a form. They didn't even bother to fill in our client's name after their standard, whatever this is. Our client's name basically didn't appear on it.
I mean, the moral of the story, this case was, we dismissed the case.
This case died because of this report.
This was the reason we dismissed the lawsuit and did not refile, because we lost all confidence in the report, in our experts' ability to offer.
Quite frankly, and this is very true, I don't mean to exaggerate, if he hadn't been the father-in-law of our co-counsel, I would have sued him for breach of contract. We hired him to perform a job, to use reasonable care in doing it. And getting this kind of garbage that absolutely killed the case, there's no fault of it, but the doctor's fault.
Because there's nothing we could have done with this to rehabilitate it in any way. So, anyway, don't write reports like this. As you're thinking about how long your report needs to be, you need to think about what the purpose of the report is, because there's different kinds of reports. With the coming of tort reform, different states have enacted statutes that require attorneys to obtain preliminary reports from experts. That essentially in Missouri, we need somebody to say that essentially that there is reason to believe that the doctor has acted negligently.
You know, and it's kind of like in preparing a witness to testify, rule number one is tell the truth, and when all else fails, go back to rule number one. Rule number one was know the rules. And so if you have to write a preliminary report, you'll refer back to rule number one, figure out what venue you're in, figure out which rules apply to the preliminary report, read it, and then satisfy it. So in Missouri or in Illinois, we'd go to the statutes dealing with what a preliminary report has to have. It's very different from Rule 26A2B, and we would just have the expert comply with that.
Because it is early in the case, there's no expectation for a lot of detail in it. And actually, when I had this conversation with an expert, I said it was just a preliminary report that I needed. I explained to him that really brevity would be just fine. I didn't need anything more than that, and he didn't have enough time to really fully develop his opinion. So I didn't want him later being impeached on something without having the benefit of deposition testimony.
Just a little bonus takeaway. These preliminary reports are big opportunities to make money. I mean, lawyers are very comfortable paying $1,000, $2,000, $2,500, $3,000 for preliminary reports to get a short, plain statement that the opposing party was negligent or did something wrong, and then they file it, and chances are you're not even going to be deposed on that. You're not going to be a testifying expert just because you write a preliminary report, so you don't have to worry that you make your words sweet because you might be eating them later.
Yeah, right. Credit to
John Wright,
who sent that in a question. But and you could actually tell and we've done this before with experts who said, I really prefer not to testify in the case or to give a deposition or trial, but I'd be happy to give you a report preliminarily, and we've done that.
So consider the purpose.
Yeah, whether you're a consulting versus testifying expert would affect the
big difference. Meaning, I mean, if you're a consulting expert, your report is only going to the lawyer that hires you. You can say whatever you want to in it. You don't have to satisfy Rule 26 if you're just going to be a consulting expert. But if you're going to be a testifying expert, you definitely have to play by the rules.
And if it's a Rule 26 report, we talked about that. So there's no hard rule as far as how long it should be. Just consider what you're doing, and when in doubt, talk to the lawyer.
One page. It should not be one page. Do you feel comfortable saying that?
Yes. Yes. Well, a preliminary report could be.
If I'm spending $2,000, it should be at least 2 pages.
All right. Mistake number 3 is being unfamiliar with your audience. Who's going to read your report? And as I thought about this, we were thinking, really, the potential audience for your report is smaller than you might think. There's only a certain number of people that are actually going to read your report. After the hours you spend putting into it.
Now, if you write such a lousy report, it might be circulated by plaintiffs or defense bar throughout the nation, where it would be used against you every single time that you testify.
That poor doctor has now had his crappy report shown to at least 85 of you, and we've used it on a couple other occasions. So, anyway, here's your potential audience. First, the lawyer that hired you and potentially their client is going to read the report. You can be sure of that.
And they're writing the check, so make them happy.
That's right. Next, the opposing attorney, if he or she is worth anything, is going to read your report.
He's going to try and rip your report apart.
Try and destroy it. And then if there's an opposing expert hired, they are probably going to read your report.
So they are the ones that ultimately will read it, but ultimately there's one person, if a motion for summary judgment or directed verdict is filed, that is going to be the most important consumer of your report, and that's the judge.
The judge.
Ultimately, the purpose of the report is to show this. Now, if you take away nothing from this today, take this away. The purpose of your report is to establish that a reasonable fact finder could determine that the opinions that you offer support one of the necessary elements in the case, whether it's causation or damages or duty or breach or something like that. Whatever your opinion that you're offering is, that a reasonable fact finder could rely on that in reaching a conclusion. And if the science isn't on your side, if the facts aren't on your side, the judge might say, based on this report, no juror could find this conclusion to be true. Therefore, I'm not going to let this case to the jury on this issue. So ultimately, the most important consumer of your report may be the judge.
And it would be beneficial to know something about the judge or about the other attorney or the identity of the opposing expert if you can get that. And you can get that information from the attorney that hired you and really dive into that. So it's important to know, if you look at the list of those who are going to consume your report, at least 3 of the 4 or 5 that are listed there, they speak a little bit of a different language than you do.
And 3 out of the 4, their opinion of your report doesn't really matter.
That's right. So, that's right.
I mean, it's true.
So it's important that as you write your report, and this is mistake number 4, that you're speaking the right language.
Now, some of you may disagree with this portion of our report writing presentation, but we don't necessarily want you to speak like lawyers. We're not going to make you use our language, but we want you to speak in language that a judge or a jury can understand. And what do we mean by that, Nathan?
Well, we were talking about the structure of a report and how you write. I mean, there's a couple things that come to mind. And what Craig and I were talking about before the presentation is when we first started law school, one of the early presentations we received is how to write like a lawyer. And when we structure our arguments, our persuasive things, there's a general format that we follow, and you can remember it by crack.
Now, don't be alarmed that we said how to argue. I mean, when you reach a conclusion, you are arguing in favor of that conclusion. You're not arguing in favor of the person that hired you. You're arguing in favor of your conclusion, so you're defending it. And crack means?
Crack, first thing you write is your conclusion. In your case, it would be your statement of your opinion.
Isn't it unusual that Rule 26A2B1, the very first thing that your report has to have is a complete statement of all your opinions?
Shocking.
Shocking. So you may not like this format, but it's what the rules require.
And really, if you're trying to appeal to the judge or the attorney's senses, I mean, this is something that the judge will, a format that the judge will have read every day for the last however long he's been on the bench or as practicing as a lawyer. So
what's the R stand for?
R is the rule, it's what we call it, but in your case, it would be your basis, your reasons, or your methodology for arriving at your conclusion.
Isn't it also coincidental that the second thing required under subparagraph I is the basis and reasons for reaching them? So we've satisfied two elements of Rule 26A2B1 right here.
A stands for analysis, and really this is where you apply the rules or the science or your expertise to the facts in front of you.
Once again, we're to the next required element.
Facts and the data considered. And then to wrap it up in a nice little package, you finish up with your conclusion, again, your opinion.
That's just good debate skills. I'm going to tell you what I'm going to tell you, I'm going to tell you, and then I'm going to tell you what I told you.
And by way of example, I want to tell you about a case that Craig and I have. It's just a car wreck case, but there were two young ladies that were
drunker than Cooter Brown.
Incredibly drunk. So drunk that neither of them can remember who was driving.
I mean, I've not had any evenings like that recently, but these ladies did.
They did. So there's a highway patrol person. The highway trooper offered some testimony that person A was driving the vehicle.
Not our client.
Not our client. So if he was writing the report, or if I was the trooper writing the report, I would say my opinion is that person A was driving the vehicle.
How do you know that?
I would follow that up with some of these physics, how he came up with it, the math.
He used DNA,
the expertise, DNA, all these things, anything that he relied on. I explained those, set those out next. Then I would precisely apply those to the facts of the case. This airbag went off. This person was flying this way. The car ended up here.
There was blood on the airbag.
There was blood on the airbag. There was hair on the visor, on the doorpost. Be very specific about how those principles apply to the facts of the case, and vehicle direction, stopping position, all these things. And then I say, and so person A was driving the vehicle.
So that is a simple example of how to state your conclusion, your basis, your reasons, what you relied on, and then restate your conclusions, and you cracked it all up.
And really, the reader of your report, as they're reading, they should take these small logical steps that ultimately lead to the same conclusion that you reached.
Fantastic.
So your structure can help get you there.
The language can help get you there, too, by not being boring.
Boring. And not just the language, but your entire report. Now, folks, it's 2012, so we're going to prepare reports like it's 2012. Instead of writing reports on our typewriter that we maybe used to use, we need to get in the mindset that we're a little more modern now.
We're in an iPad world.
We're going to do some cool things. Have a cool report.
Neat exhibits.
So you don't. We had a case where our expert wrote a report. It was a very precise report.
Old school.
Did what we needed, but it was old school. It was just words on a page.
Stapled together.
And not very memorable.
Now, the defendant who, say what you want about Briggs & Stratton and Walmart, they've got a lot of money and they can hire some very, very fancy, expensive experts. And that report that we got in that case that we're thinking about, I mean, it was like a Ferrari. Ultimately, we got the case settled and got quite a little bit of money, but boy, that report was substantial.
Well, and it stood out. And when we got it, we looked through it, and I mean, my first impression was, well, this is a quality report.
My first impression was this cost a fortune.
Right. So, but you know, the first impressions are very important. Now, diving into it, we were able to attack it a little bit, but you know, there's a lot of resources available to you as far as putting pictures into your reports, different diagrams,
even video animation,
all sorts of cool things you could do. And really, I wouldn't see any problem with referencing, you know, DVDs, video that you've recorded.
Absolutely.
All sorts of stuff. And really, there's an opportunity to think outside the box and distinguish yourself from those experts who are just typing things out.
All right. Q&A. We are running right on schedule. I'm going to take Angela's question, which is, what if my opinion is not in favor of the firm that hired me? That is an excellent question, and you've just made the successful transition from a testifying to a consulting expert. I would say if that is the case, your first responsibility is to let your hiring attorney know immediately so that they can see if they can hire someone else. You're not being paid to give a specific opinion. You're being paid to give an opinion, and if your opinion doesn't please the person that hired you, let them know.
Well, and really the attorney is not going to be upset with you. That happened in one of our cases, and the expert looked at the medical records and said, look, this is what I think.
And you're not going to get there. That's what he said.
I can't get you there. And we looked at it, and that's why we hired him, to tell us whether we could get there or not.
Believe it or not, attorneys don't want to try and turn sow's ears into silk purses, so to speak.
Good attorneys don't.
I mean, we've got much more work to do than time to do it, and if a case isn't meritorious, we don't want it. Most attorneys don't. So your job is just to give an honest opinion. The publications seem to have generated a lot of questions.
Yes.
What does all publications mean? Does that mean course notes that I wrote? Does it mean something that I put on a website? I'd say, you know, web publications, to the extent that a website is able to be copyrighted under the U.S. copyright law, it is a publication if it is distributed to the public. So if you're writing a blog article that's going out there and it's been published, you might list, I wrote for this blog. Not necessarily every blog entry, but if you blog, you might list that. I don't know that that's been litigated to the highest levels in the federal court system, but all publications means all publications.
Well, not in a federal case, but we had an issue come up in discovery where we requested the opposing experts, like PowerPoint notes or presentations they had given.
Yeah, I got one in a dental negligence case here in Missouri. I was able to get a speech that she gave because she wrote it down to a Rotary group, wherein she offered an opinion that was completely contrary to the position she was taking in my case, and they fought me on it, but notes that she made for purposes of a Rotary presentation were discovered.
And I don't know if you've seen this, Craig, how in a federal court would rule on that, whether they'd be required to disclose those as part of their publications going 10 years back. But
I mean, ultimately, the best I can tell you is have a complete list of everything that you write, and then you can ask your hiring attorney what they want you to include or what they don't want you to include, or you can not give them that option and you can include it all. But the risk you run is if you run afoul of the all publications rule, which is in Rule 26A2B, subparagraph 4, you're going to be excluded because you haven't satisfied the rule.
Christopher Swan wants to know if he needs to include negatives in his report. I assume he's talking about photographs, but I would not. I would not think. The reports that we've got and we've had experts provide that have pictures have just been copies of the original pictures.
Steve Ashton asked a question that we get a lot. What about reports that the expert creates that an attorney wants edits to? Do all of the prior reports become discoverable? Is it better to use a working report instead of edited reports? There are different attorneys with different opinions, but the way that I view the current state of the law is there is a report and there are drafts of the report, and if you draft a report and make changes to it, it is discoverable. That's why I, as a hiring attorney, never ask to see a draft of the report. Well, and if I do ask to see a draft, but I do not make changes to it. I do not write on it. I do not.
Well, you don't make substantive changes to it. There may be some.
Sure. I mean, the big risk is if the attorney reaches opinion A, and then he sends it to the lawyer, and then all of a sudden there's a version of the report reaching opinion B, that expert is near worthless.
Well, because you're going to get a deposition when after you've produced the draft of your report, and there's a change. If I'm the lawyer, I'm going to say, well, what changed between version A and B? Why did you change your opinion? And if it's, well, I talked to Craig, and he said he didn't like opinion A, so I changed it to opinion B, the case is done.
Yeah. So, and I always look at the report before I send it out, and I make the decision, am I going to use this expert, or am I going to make them a consulting expert? And I might make a couple of stylistic changes, but absolutely nothing substantive. Just one last question. Chris Swan asked, do I need to include negative things that go against the client?
He was clarifying. I thought he said negatives about pictures.
Negatives about the client's position. Do I need to include that? Well, no, but you don't want to ignore the obvious. If there are some very obvious things that you need to consider to reach your conclusions to address, you need to say, I thought about this, and this doesn't apply because. If weather's a factor, if speed is a factor, if there's some other things that you need to consider and you can resolve them and still reach the same conclusion, I would not take the ostrich approach and stick my head in the sand, because then at deposition you're going to get asked that question and say, well, if this was an important thing for you to consider, why didn't you mention it?
And really, it bolsters your credibility. If potentially the judge or the jury sees, hey, this guy has dealt with, has recognized something obvious, I can believe what he or she has to say about his ultimate opinion.
All right, great questions. Now keep these coming. We're going to have another 5-minute Q&A session at the end, and so we're able to answer all of the questions submitted up to this point. So if you submit some now, we'll get your questions answered before the end of the presentation.
All right. So the next discussion.
Yep. Before you start, we have an expert that's been waiting patiently. Can we squeeze in one more question?
Sure.
Which one is that, Matt?
It's a question I got submitted to me over email. What should the expert do if he has already written a report but hasn't finished the report? And does the lawyer have, or can the lawyer suggest that he or she rewrites it, or can they reach out to the attorney and say, hey, I'm going down a path here, and do you want me to rewrite this report, or continue on as they're writing it?
You know, the way that I approach that, Matt, is anything that expert talks about with the lawyer, if they're a testifying expert, is 110% fair game. So that is kind of a fact-specific question.
Discoverable, he means. I mean, somebody can find out what we talk about with our experts.
I mean, if I have an expert that calls me and says, there's a lot of unknowns in that question. If the expert calls me and says, man, I'm just so unsure what to do, I'm starting down this way, but if you want me to go down this way, I'm willing to do it, that tells me that he's a hired gun and his opinion is probably worth a little bit less than somebody that very decisively reaches an opinion on his own based upon the facts that was provided. Maybe that expert needs more information and says, I'm working on this, but I can't get to the finish line until you tell me the answers to A, B, and C, because I need to know these facts before I can reach my conclusions. I don't have a problem with that, but you really have to avoid doing anything that, if discovered by the other side, would damage your credibility.
Or it looks like the attorney is shaping the opinions in any way. I mean, that'll just kill a case.
Call it what it is. Juries already believe that because you get paid money, you're offering opinions that favor the guy that hired you. So we have to make sure that we avoid even the appearance of impropriety or bias.
Okay. Well, thank you. I was interrupting, but please continue.
No problem. All right.
Number 6, the report that shows that the expert is distracted or hyper-focused on some issue that's not related. We always talk about chasing rabbits around here.
One of my favorite pastimes.
We're working on something, and then a rabbit hops out, and we're off chasing another direction. And that can happen in your reports as you're writing them. Federal Rule of Evidence 702 basically says that we hire expert witnesses to testify or present evidence to help the trier of fact determine a fact that is in issue.
Now, the trier of fact is the judge if it's a judge-tried case or the jury if it's a jury case.
But the only thing that experts are called on to testify about are those facts that are an issue, which means is there something that we have a question about. Now, there may be a ton of other facts in the case that are not an issue.
If everybody agrees that the driver was speeding, we don't need to do get our drag stick out and go out and do a speed calculation.
So there may be certain things that distract you. We thought about there's some distractions outside of the case, and those may be things that personally you've researched and you're interested in that may tangentially relate to the case, but really, like we talked about, are not one of the facts that are not an issue. But there's also some distractions within the case, and one of those could be the opposing expert's opinion. If you get so bogged down in well, I have got to destroy the other expert, you may spend so much time in your report dealing with that you lose an opportunity or forget or do not completely explain what your opinions are.
And this is particularly true for experts that are testifying on behalf of defendants, because your job is twofold. It might be to deal with cross-examining, for lack of a better word, the plaintiff's expert, but also your job is to support the opinions that the defendants need to prove any affirmative defenses that they have in the case. So the plaintiff's expert has basically one job, but the defense expert has two jobs. Now, for you plaintiff's experts, you're most likely to get distracted after you've seen the defense expert's opinion, which makes you so mad that he has said that you've used improper methodology or that you've forgotten to take into account some things that he believes are important,
or just had a different opinion than you.
You get distracted from your very solid opinions that you've already offered. You go back and restate what you said and point out why their defense experts, when you do your rebuttal report, you just get in and get out. Don't get distracted by the fact that they've said that you're not a good scientist.
If there are issues that the opposing expert has raised that you need to explain, be sure to do that. But don't get so bogged down in, taking it personally, I guess, that you lose your focus. It's important that as an expert, you know what your role is within a specific case. You may be called on to offer an opinion about, here's the elements of a negligence case. You may be hired to give an opinion as to what caused the injury. And there may not be any question what the damages are. So you in your report do not need to spend time on what the person's damages are or are not. Instead, your report should be focused on causation. Now, if your hiring attorney says, I need an expert who can give me causation and damages and give me a strong opinion on that, be sure you do that.
Now, one of the things that John Wright mentioned before we started was some of the words that we use might inadvertently cause an attorney on the other side to believe that you're offering opinions that you are not offering. If you use the word reasonable, maybe you're talking about duty of care. If you use the word damages, maybe all of a sudden they believe you're going to offer testimony about damages. Maybe if you say prudent, they think that you're getting into standard of care. So in choosing your words carefully, knowing your role is going to help you choose your words. So there are, John Wright said, well, these are loaded words. They have lawyer meanings, but not necessarily scientific meanings. That might be true, but if you understand your role, you'll be very comfortable and confident in fulfilling that role by choosing words that support what the objective that you're hired to achieve.
And be sure at the outset of the case when the lawyer hires you, you make sure you know what she or he is what those expectations are. I try to do a good job when I'm talking to my expert at the beginning of the case, saying, this is what I need from you.
In our car accident case, maybe you have to deal with damages because one of the reasons that you believe that the other girl that we were the passenger is because at the hospital they saw the reverse printing of the word Taurus across our forehead from the dashboard. And so you might mention her damages only to support your opinion of duty and breach. So sometimes you do have to get into other issues, but always come back to your original role. Why were you hired?
Yep. All right, and in that context, you don't want to forget as you're focused in on these other issues why you were hired. You don't want to forget about how you got to your opinions.
Now, again, this isn't a seminar today on Daubert or on Fry, the two main tests for determining the admissibility of expert opinions, but methodology rules the day on a Daubert challenge. And it's not your opinion. Somebody may say your opinion is dead wrong, but if you didn't use generally accepted methodology in getting there, you'll never get to tell the trier of fact what your opinion is.
And generally accepted is just one of the factors under Daubert. I think that's the Fry test, but that's an important factor. So be sure you can explain why the methods you used at arriving your opinion were reliable, generally accepted in your professional community.
And that's R for the crack. That's your reasons in reaching your opinion. So we had, believe it or not, one of our federal judges in a motion that we filed, we did not have an expert to support what standard deviation is or how to do a standard deviation calculation, even though it's generally known how to, for anybody that's taken a statistics class, how to calculate standard deviation. So don't assume that anything is generally accepted, that you might need to explain even the most simple things, that it's generally accepted that this scientific formula calculates, the mean difference between a number of points in a set.
And really, you don't even have to have taken the statistics class. As long as you can go to Wikipedia or the Google, you can figure it out, right, Greg?
I guess so. I'm a big fan of Wikipedia. I think if it's on Wikipedia, it's probably true, because all of you guys with lots of time on your hands, you sit around at night and you correct Wikipedia. That's true, isn't it, Nathan?
I'm sure it is.
That's what these guys do.
I'm sure. All right. Okay, mistake 7. Now this is this bugs me. The poor English. It's a distraction. It will take away from your report. You may have the greatest opinion. You may have used the most reliable methodology. You may be the foremost in your field. But if you can't write a complete sentence or commit some of these other heinous grammatical crimes,
you are the one that is keeping the dangling participle alive only by your own efforts.
It's a total distraction, and your opinion and your message will not be effectively conveyed to the audience as we talked about. So we understand you're not, some of you may be English teachers, but many of you are not. But there's some basic things, and here's just a sampling of some things that to keep in mind as you're writing your report. There's words that your and your, make sure you know the difference between those. Homonyms, principle, there, and there.
Affect, effect.
Not a homonym, but do know the difference between those noun and verb forms. It really will boost your credibility. Active versus passive voice. Craig, what's the difference?
Well, look, if it's a car accident case and we're going to say what the facts are, we would say vehicle A struck vehicle B, not vehicle B was struck by the driver of vehicle A. Let's just say it simply. We take a sentence that would take 2 lines to say and we condense them into one sentence. Active voice is always more persuasive than passive voice.
And it's easier to figure out who's doing what in
She
the sentence.
shot the gun rather than the gun was struck by, So we want to talk actively about things happening using active words.
Prepositional phrases, those tend to hang on at the end of sentences, on the bush, over the hedge, whatever.
From the east.
From the east, a lot of it is unnecessary.
And as you work on being a better writer using active voice, you'll find that your need to rely on prepositional phrases will go away.
And what it does is it helps you make your sentences more concise and precise because you're not jumbling it up with a bunch of unnecessary words.
And I think some experts that we've hired really thought they got paid by the word, and they might have written in short sentences, but there were so many things that were included that were absolutely immaterial to the conclusions that were offered. I mean, doctors, if you're any doctors listening, you do SOAP notes, which is, you have a patient come in, you do subjective, objective, assessment, and plan, and you write down lots of things. Pretty much anything that the patient tells you, you write it down because that's their subjective complaints or their history in doing a history and physical. We don't need all of that in a report. Only include those concise sentences of statements of fact, of things that you need to satisfy rule 26A2B. It's not your opportunity to show off about how much you can write or how much you know. It's how can I satisfy Rule 26A2B quickly and then sign my name and get paid.
Now, lawyers are not innocent in this. There's a lot of lawyers that use flowery language and lots of excessive words.
The problem with lawyers is we're too damn verbose.
So we're trying to cure that one lawyer at a time. Anyway, like we talked about, structure message. So how do you fix that problem? One of the solutions, after you draft your report, read through it out loud.
We're not kidding.
Out loud in front of a mirror, sitting at your desk, whatever, but you'll be amazed as you read through it how obvious some of those grammatical mistakes are.
And that's because, you know, the folks are visual, some folks are auditory, some folks are tactile, some folks are emotional. So based on your personality type, you may not notice some of the mistakes in your report until you hear them. Maybe you need somebody else to read it to you. But, I mean, it will make you an incredibly strong writer if you're an auditory person to hear your report.
And having someone else proofread it is nice. You've looked at the same thing for a long time, and it's easy to skip over things after you've read through it 15 times, or however many times you read it before you're done. But having a fresh set of eyes is really helpful. And it doesn't even need to be a colleague, another professional. It can just be a secretary or someone.
Hey, Chris Swan, give me an example of what you're talking about on that last question.
All right. Your computer comes with a spell checker.
Use it. There's no additional charge for the spell checker on Microsoft Word.
And then this one, it sounds crazy, but if English and writing is a real challenge for you, I would see no problem. I mean, if I was in your shoes and I had a problem with that, I would seriously consider taking a class. If I'm investing the time and doing work as an expert, that'll really bump my value if I can write well. So a class will help you do that. Greg has a tip. Read the report backwards. That's interesting.
You mean like Ozzy Osbourne backwards?
Probably not.
Start at the end and go to the beginning.
Yes. All right, number 8, and this goes back to our crack thing, is a failure of experts to apply the science to the facts.
This is where you can really shine. I mean, you have this basis of scientific knowledge or your specialized knowledge that you've acquired over a lifetime or over your career, and not just reaching the opinions and saying, I say it, therefore it is. Using the science and articulating how you got there, using all of the tools that you had to evaluate in your mind and write it down. You know, Chris Swan said, what about an opinion that's based upon an experience or judgment that doesn't have a scientific basis? That's shaky ground. I mean, if you're going to state a conclusion in federal court that isn't based upon any kind of science, well, under Rule 702, are you an expert? Do we need you to state the obvious? We never need an expert to state the obvious, and that's another basis of excluding them. But the more common basis of excluding them is they're simply reaching a conclusion that has no basis in scientific fact.
You know, I guess the one way you try and get around that issue is almost like a statistical thing. You know, I've seen this has occurred, this set of circumstances has existed in 500 other cases before this one, and in every single one, this has been the conclusion, and the same conclusion happened here. So we can draw certain conclusions from that, but that'd be like Craig said, that's some shaky ground to be on.
But ultimately, this is where you put the meat on the bone.
And it's important because this is ultimately what you want the judge or the jury or the fact finder to do. You say, look, this is the science. I'm trying to explain it to you, and this is why it works in this case. So your report is an opportunity to kind of prime the pump and say, look, this is why this science works in this case and why my opinions are valid. So to do that, you have to know what the facts are, so that as you're writing your report, you can fill those in and make sure you do a thorough job of writing down the facts.
And don't forget to ask for more facts. If you need more to apply the science to, the lawyer's chances are if they don't have the facts to give you, they can send a discovery request out or send a deposition and get you what you need. So the lawyer's job is to give you the tools that you need to do your job and to do it well and to do it consistently.
And this kind of ties into our 9th mistake, and that's that you haven't done enough groundwork before writing the report. And now listen, a lot of experts will say, well, this is the attorney's fault. Sometimes it is. Sometimes it is. But there are a lot of things that you as an expert can do to lay that groundwork. I had a case where, it was a nursing home negligence case. The expert went out on his own and pulled some reports, some public records about the nursing home, and used those as he was developing his report. Which was great. I mean, there's obvious reasons why you don't rely only on the attorney for your information.
The learned treatise rule, if you're not familiar with that, a learned treatise is one that's consulted on or relied on by experts in your field. It might be the medical dictionary, it might be the book of pharmacology, or it might be the DSM-3 or 4 or whatever we're on for psychologists. Don't be afraid to in applying the science to the facts, to go to those learned treatises, because the learned treatise is admissible regardless of whether you say it contains accurate information. Anything contained in a learned treatise can be used to support a conclusion, and that's perhaps the easiest way for an expert that doesn't want to do a whole lot of work plowing new ground to really shine, is to rely on learned treatises, and so many don't. I had one lawyer, I said, one dental expert said, well, I really need to know that. He said, well, everybody knows that. I said, well, if everybody knows it, give me a learned treatise on it. So he drove up to the dental library in Waco and charged me $500 for copying something out of a book that he didn't have in his office. But the learned treatise is...
So Craig's not bitter.
Yeah, I'm not bitter. I haven't forgotten about it. Is a way to really help you achieve this without too much effort.
But you don't want to get into a situation where a deposition, the other attorney's asking you, well, where did you hear, or how did you know that person A was driving?
Craig told me.
Craig told me. Nathan told me. Did you look at any other documents? No, I just listened to the lawyer.
Yeah.
And that's that.
Our role is advocates for our client. Our role is to make sure that we win and the other side loses. It's not about truth, justice, and the American way.
We're obviously biased in favor of our client.
Relying on us is not going to help your report stand independently on its own as an unbiased conclusion reached by an unbiased professional.
So that's why it's important that you look for ways that you can gather information on your own. So we got about 10 minutes left. Let's jump through mistake number 10, do a little Q&A, and then we'll wrap up. And the last one, we kind of touched on this, but that in writing your reports, you ignore the opposing position.
How do you know what the opposing position is?
Well, there's a couple ways. If you're a defending expert, you will have probably seen that if you've read through the plaintiff's expert's report already. But you can, and we're going to get to this, if you haven't seen the other party's report, you are an expert. You likely can anticipate what some of those opposing points are going to be.
I mean, a lot of you experts in the field that have done this for a long time, you know who your adversaries are that work for the other side. If you're a defense expert, you know who the plaintiff's experts are. If you're a plaintiff expert, you know who the defense experts are. You've been down this road before, and you know what they always say. Their opinions don't change generally.
Well, and, you can always ask your attorney to locate cases that the other expert has testified in.
Or depositions that they've given.
Yeah, depositions, trial transcripts, things like that. And there's ways to dig up what the opposing party has opined to kind of anticipate what those arguments
Think of all the additional billable time as an expert you can put together by simply suggesting to the attorney that there's more work to be done that they haven't done.
So true.
You're just trying to help them.
But the thing that you don't want to do is ignore those. And we talked about that a little bit before. Did you know ostriches don't actually stick their heads in the sand?
I did know that. That's a myth that only defense lawyers promulgate.
Oh. All right. So in your report, the best way to handle this is to first acknowledge what the position is, the opposing position is.
And then annihilate it.
And then kill it. That's exactly right. It's a way that you can objectively kill them before they even. And really, if you can anticipate what their position will be, you really take the rug out from underneath them when they go to write the report. So it's a great opportunity for you to add value to the case early. We talked about that. So let's do a little Q&A.
Q&A it is.
We have read drafts of our reports. This is Zachary Eubank says, we have read drafts of our reports over the phone prior to sending to the attorney. Is this encouraged rather than issuing a draft?
He follows my rule number 4, which is destroy the evidence.
Kill the baby, I think is what you said.
Right. If you read it over the phone, I, as the one that birthed the expert report by hiring the expert, I own it. I can decide whether I want to kill it. And if you read it to me over the phone and I don't like it, then, Zachary, you have become the consulting expert, and there is no written evidence that you reached an opinion that was contrary to my case, and I can go see if another qualified expert will tell me that maybe there's hope for my case. Maybe there's not. But reading it over the phone is okay. But then on the other hand, putting it down on paper and sending it to them, if they're going to help you make the transition from testifying to consulting expert, having the report in writing won't be a problem.
But if you do remain on as a testifying witness, though, that telephone conversation is discoverable. So I can imagine how this cross-examination is going.
Here's how it works. Let's say, and I don't know, Mr. Eubank, what field you're in, but let's pretend that you were a physicist, and you called me up and said, hey, Craig, I'm preparing to say that your driver was exceeding the speed limit based upon the length of the skid marks. Is there anything I need to know about the facts of this case that might change that opinion? Like, was it wet? Was it uphill? Was it concrete? Was it asphalt? How old was the concrete? Then you're going back to your attorney seeking information to help you reach an accurate conclusion, not saying, hey, if you don't like this opinion, let me know and I'll figure out a way to change it.
Dave Kirby has an interesting question. What should I do if the parties have stipulated to something that is contrary to my opinion?
Assume it is true unless it is so against your moral convictions that you can't, in good conscience, rely on it.
Yeah.
I mean, once a fact has been stipulated to by the parties for all purposes, it is true.
So you need to use that as one of the factual bases for your opinion. Loretta asks, what about labeling the report work document? And I assume she's talking about work product. But what you label it is not necessarily what the court is going to find it to be. So, if I'm firing stuff back and forth to the lawyer, and drafts that are being changed, and I keep stamping it work product.
The only thing
just because I call it that doesn't necessarily mean that
you can call it initial opinion or preliminary opinion if you anticipate you're going to get a big chunk of data in later that might change your position, and that way you've left yourself an escape route.
Yeah.
A lot of folks, and I love it when my experts say at the very end, now this is your second takeaway, these are my opinions based upon the information that's been made available to me now, and my opinions may change if I'm provided with additional information later on. And that way, when you get to deposition, and the opposing lawyer hands you an interrogatory that you've never seen, saying, well, did you know this? No. So your opinion's wrong. No. I can modify my opinion based upon new information, and my opinion might be slightly modified after seeing this. I didn't say, this is my opinion once, now, and forever. I said it might change if I learn something new later on.
Christopher Swan wants to know if you're not getting time and money as the case goes on. Is it easy to walk away? Yes. Yes. Just tell the attorney you're done. Terry Ives wants to know, as a medical provider, who apparently she does testing of the client, provides opinions. How do those results be presented?
That would be an independent medical examination. Now, if it's in federal court, you still have to comply with Rule 26, but there are special rules governing IMEs, and IMEs, I don't have the rule in front of me, but when in doubt, go back to Rule 1, and Rule 1 is know what the rule is. So make sure you know what the IME rule is at the state level or the local level. You might be doing a functional capacity evaluation, or you might be doing a strength test or something like that. If you are going to be a testifying expert and reach conclusions, though, ultimately your opinions will have to satisfy Rule 26.
One of the things you can do in that situation is, if you want to have something that looks more like a medical record with the SOAP stuff that Craig was talking about, you could attach that as an addendum to a report that's more in the crack format.
Well, sure, because that would be an exhibit that you might use at trial. I did an examination, and a careful doctor following the standard of care will do a history and physical, and here's my history and physical report attached, and based upon my history and physical, then you get to the whole assessment and plan. I reached the conclusion that they're a malingerer. They're lying about it. They can really do a full day's work with no restrictions. So your report dovetails into the history and physical as an exhibit.
Steve, I don't think it makes a difference whether you send the report by email or hard copy. Some folks like to have hard copy, some people are paperless. It doesn't matter.
A little extra tidbit. By way of discovery now, electronic data is a document. Anything that is on your computer is an email or a note. It's just as if you printed it out and put it away in a file somewhere, and it's all discoverable. So it might be harder to find, but it is discoverable if somebody asks for it.
Wayne, that's a good point on yours. There are pros and cons to acknowledging culpability among the parties. I mean, that might be something like Craig's talking about where you mentioned over the phone, hey, I think your client may have screwed up too. That would be something that I as an attorney would want to know before that was put into a report that I'm submitting to an opposing party. But if it's there, that's an issue I need to know. I want to know that so I can deal with it as the case goes on.
And if you step back and go to a 1,000-foot view on the opinions that you offer, there is science behind everything. So, for example, if you were called in on an electrocution case where you were asked to give an opinion on how a worker was most likely in a working position when he got electrocuted, I was going to say executed, electrocuted, you might think there's nothing scientific about that, but if you say, based upon my knowledge and experience in the field, in order to, at this location, change out this particular circuit breaker, you would need to be in this kind of position to put the leverage on the breaker when you pulled it out. Or if it was an overhead bucket case, we know from where the bucket was at the time of the electrocution that it was extended and it was this far, and based upon the angle of reach and his height, he would have had to have been in this position in order to make contact with the line. There's science everywhere. You just have to look for it.
It depends on what your expertise is, how you deal with that. And then final question, Tim, is viewing a preliminary report on GoToMeeting a good alternative to a draft report? It's probably about the same thing. It's technologically very cool, but it's essentially, I think it's the same. You have the same issues there where you don't want the attorney affecting affecting the report.
Well, with that, I'd like to conclude and thank everyone for being with us on this very hot Midwestern day. Our screen on our computer is actually starting to liquefy because of the heat. We've certainly enjoyed the opportunity to visit with you guys, and if anybody has any further questions, you can email them to Matt privately, and we'll try and get back with you offline.
Okay, excellent. Well, thank you so much, Craig and Nathan, for your time and preparation today. And thank you for the experts who spent an hour of their time with us to learn more about report writing. As I mentioned during the introduction, tomorrow morning we'll send out a link to the archived recording of this webinar. The archived recording will be posted on our website, and you will be given an access code to bypass the on-demand fee for viewing the archived recording. In that email, I will also include a copy of the PowerPoint presentation that was used during today's program. If you have any follow-up questions or comments, please email me at mhyde@tasanet.com. As Craig said, if you do have any questions for the presenters, I will forward them on to the presenters, and hopefully they'll respond to your question. And please let us know if you have any constructive comments on how we can make these programs better. We do take all of your comments under consideration, and they do help us to put on better programs. With that, there's going to be a survey that will appear on your screen after you leave today's program. Please take a minute and fill it out. We do take that feedback under consideration and use it in future programs. Thank you again to Craig and Nathan. Thank you for everybody who was in attendance, and we look forward to seeing you at future events.